The Compliance Perspectives podcast is sponsored by Athena, customizable compliance training, an employee hotline, and case management all in one tool. Welcome to the Compliance Perspectives podcast. I'm Adam Turteltaub from the Society of Corporate Compliance and Ethics and Healthcare Compliance Association. Joining us today from London is Jonathan Armstrong. Jonathan is a frequent speaker at our conference and partner at Punter Southall. And today we're going to be talking about what the European Commission has been doing in the area of general purpose AI. First, Jonathan, thanks for joining us. Second, in July, the Commission issued its new General Purpose AI Code of Practice, which is broken down into 3 chapters: transparency, copyright, and finally, safety and security. I'm hoping in this call we can go through each of them, if that's okay. First, can you tell us what does the transparency chapter say?
Yeah, thanks very much, Adam, and thanks very much for the invitation to come and speak again. I think the first thing to say before we start is it's a voluntary code, so it's not mandatory. It fits into the EU AI Act in a sort of roundabout way. Obviously, as you said, the Code of Practice was introduced in July this year. The EU AI Act came in August last year, but the provisions come in over time, and the bit relating to GPAI isn't law yet. The other thing we should perhaps say is, what is a GPAI system? Well, it is a system that is, quote, intended by the service provider to perform generally applicable functions such as image and speech recognition, audio and video generation, pattern detection, question answering, translation, and other applications. So it's a little bit like Gen AI, and most Gen AI will be GPAI, but they're not interchangeable terms. So, as you rightly say, if you've got a GPAI application, then you might want to follow this code, and you'll obviously get credits with regulators if you do. There are penalties if you breach the Act, but those penalties aren't yet in force for GPAI. To answer your specific question about transparency, well, transparency is in some respects at the heart of both the EU AI Act and at the heart of GDPR. The first thing to remember is that whilst this code is voluntary, GDPR is obviously mandatory, and the majority of the 6.1 billion plus euros worth of GDPR fines that we've had have featured transparency. So transparency is going to be, I don't know, the mustard through the Chicago dog of compliance when it comes to AI, if you like. It runs absolutely through both GDPR and the EU AI Act. And effectively, what the transparency requirement is in the AI Act and the code is to keep up-to-date technical documentations of the AI model. That's going to include things like how it was designed, include things like the technical means by which it performs its functions, and also things like known or estimated energy consumption. There's obviously a big debate about the ESG unintended side effects of AI, the fact that asking a Gen AI application a question takes about a litre of water, and in some parts of the US and other parts of the world, water's a scarce commodity. So the aim is to look at all of those type of aspects as well. The code includes a model documentation form. It's trying to be user-friendly, and it's trying to allow people to collect the data that they need to meet their transparency obligations. And the code also recognizes the fact that many people are integrating GPAI models into their AI systems. In recruitment, for example, we're already seeing that with some concerns and some regulatory activity. The code calls these providers downstream providers, and the GPAI providers have to provide technical information to downstream providers to help them integrate, to help them do their AI assessment. So, as I've said, it is voluntary, but using things like the model documentation form might help, particularly if this is a product that you're looking to sell to other people to integrate into their systems.
Thanks for explaining that and also giving such a great overview about the code of practice and what weight it carries. Now, let's talk about the second chapter, which is copyright. Tell us what's in there.
Yeah, that's a really big debate over here in Europe. Obviously, you've got the AI providers lined up on one side who are broadly saying we can infringe on copyright rights for the greater good, and it's really important, and AI is revolutionary. So anyone who holds copyrights just got to get over it. And at the same time, existing rights providers, you know, an alliance led at times by Sir Elton John and Sir Paul McCartney, are saying that those with creative rights shouldn't be trodden on just because AI is the new kid on the block. So there's quite a difficult balance, I think, to drive for legislatures here. This debate's been in Europe and also in the UK. So the UK's got new legislation which effectively was going to look at copyright and now isn't. Effectively, what the EU AI Act says is that GPA providers have to have a policy to deal with copyright law and related rights. It says that the code doesn't affect the application and enforcement of those laws that exist. And broadly speaking, those laws tend to be country by country within the EU rather than one universal EU law enforced by EU courts. So there's going to be some complexity by that under that regime. And the commissioner reminding people that the application and enforcement of copyright and IP rights is going to be dealt with by member state courts, not some EU body. But it does set out some measures that it would expect people to align with if they're signing the code. And that's going to include things like scraping websites and observing signals, so technical signals that enable copyright holders to direct web crawlers on a technical basis. It's going to include things like appropriate and proportionate technical safeguards to prevent models from generating outputs that simply reproduce copyright and other people's IP. It's going to be prohibiting copyright infringing uses of a model in acceptable use policies, terms and conditions, those type of documents. For free GPAI, it's going to be include specifically alerting users about the prohibition of copyright infringing use by using the model. And it's going to be things like designating a point of contact, enabling the lodging of complaints. So a little bit similar to existing US laws, for example, in having somebody that you can complain to, put them on notice, and then expect them to take action.
Well, this is a troubling area. Growing up in Los Angeles and living in Los
Yeah.
Angeles, you certainly know a lot of people in the creative industries, and they're sort of more than a little perturbed by what's going on here. Now, finally, of the three chapters, the last is safety and security. What's in that one?
Yeah, well, this is where it gets even more challenging, unfortunately. And I'm going to avoid some of the really technical explanations. But the technical answer to this is flops. And I know you don't need me to tell you, Adam, but for the audience's benefit, this is floating point operations. And in really simple terms, this is the compute power needed to do a task. So the safety and security chapters only apply to those most impactful GPAI operations, and a current flop rate value, that's going to be where the computing output needed has cost you more than about $6 million as a very, very rough guide. But if you are using one of these most uh, uh, systemic risk GPAI products, and that's something that could be widespread, have a high impact on things like health, fundamental rights, then you're going to have to do an extra set of things like performing model evaluations, a bit like pen testing, looking at the level of cybersecurity protection, etc., etc. And then there are also 10 commitments that a signatory would be expected to go through in the safety and security chapter. And that's going to be things like putting in place a safety and security framework, identifying systemic risks. So doing an impact assessment. A lot of people are already doing AI impact assessments. They might be following a GDPR model of a data protection impact assessment, for example. But it's like doing that assessment, but looking at a specific process which is outlined in the code, which has specific risk-based scenarios, etc., etc. They might involve looking at systemic risk, looking at safety mitigations as part of that assessment, not only on launch, but throughout the model cycle. And then it also includes processes and measures for serious incident reporting. So a little bit like the processes that people will have in place for data breaches, for example, looking at extending those processes and having them in place to deal with GPAI applications as well.
I do want to correct something. You did have to explain what flops are to me. Once again, living in Los Angeles, Flop is a movie that didn't do well. So
Right.
the data part is well above my head. So with all the jokes aside, what's likely to happen next?
Well, again, I return to the point that it's voluntary. So some organizations, Meta's one, have said that they're not going to sign up and they think that it'll stun European companies, in their words. But those who do want to sign up, they can review what the GPAI code's likely to bring to them. There won't be a stop the clock. There's, I know, a lot of rumors circulating that the EU AI Act will be suspended. I don't think that's likely. So for organizations that think this might benefit them, time to do some analysis now and work out what's going to be required.
And my guess is it's going to be workout and reworkout given how quickly AI evolves, both in terms of the positive gains we see and then the incidents that inevitably occur with any new technology. Jonathan,
Yeah.
thank you so much for sharing your insights into this today. I want to thank all of you for taking the time to listen. I'm Adam Turteltaub from SCCE and HCCA. I hope we're able to expand your compliance perspective.